Please be seated. Can I allow me to use of both of his hands, please?
We are.
Thank you. This is a pre-hearing procedure in the matter of state against Richard Alexander Murdaugh. It's case numbers 2022 GS 15-00592 through 00595. Defendant Murdaugh was indicted for the murder of his wife, Margaret Branstetter Murdaugh, and his son, Paul Bennett Murdaugh, and related weapons charges. His trial began on January the 23rd, 2023. The presiding judge was Clifton Newman. After 6 weeks of trial, on the evening of March the 2nd, 2023, the jury returned a verdict of guilty on all 4 indictments, on which the defendant was sentenced on March 2023 to 2 consecutive terms of life imprisonment. Notice of appeals of his convictions and sentences were filed by defendant Murdaugh's attorneys on March the 9th, 2023 with the South Carolina Court of Appeals. The transcript in this very lengthy trial took several months to produce, even in draft form. Before the attorneys received the final transcript, on September the 5th, 2023, defendant filed with the Court of Appeals a motion to suspend his appeal and for leave to file a motion for a new trial with accompanying affidavits and transcript experts. After further defense and state filings on October the 17th, 2023, the Court of Appeals granted appellant Murdaugh's motion to suspend the appeal and to remand this case to the circuit court to allow defendant Murdaugh to file a motion for a new trial. On October the 17th, 2023, defendant Murdaugh received the final trial transcript and very shortly thereafter filed a motion for new trial in the Colleton County Clerk of Court's office. Subsequently, Judge Clifton Newman recused himself from further proceedings in this matter. On December the 16th, 2023, on December the 18th, 2023, Chief Justice Donald W. Bailey signed an order appointing or directing that the Honorable Jean Hafer Toal, retired Chief Justice of South Carolina, be assigned exclusive jurisdiction for the limited purpose of presiding over defendant's motion for a new trial. I promptly contacted counsel in this case and set deadlines for briefing and arguments of the new trial motions. The new trial motions were set to be argued on January the 23rd, 30th, and 31st of 2024. And after several rounds of pretrial briefs having been submitted to me, I also set today's date for a procedural pre-hearing. Before I begin, may I say that we certainly welcome members of the media, and I thank publicly Attorney Jay Bender for agreeing to be the voluntary media coordinator for this matter, as he did for Judge Clifton Newman on the trial of this matter. Cell phones are normally not permitted at all in our courtrooms, but the press has been allowed to bring in certain cell phones and laptops and electronic devices because of the non-jury nature of this portion of the proceedings. But if any device rings or sounds to receive a call or to receive an email or a message, that device will be confiscated and the owner will be asked to leave the courtroom. So please now, if you haven't already, check your electronic devices and be sure that they will not sound during the time these proceedings take place. Major topics to be covered today have been addressed by me and discussed with counsel in a short pretrial conference in my chambers. And counsel may have certain things that they will put upon the record as we proceed through these topics that deal with what should be covered. The first topic is an evidentiary hearing necessary at all? The state took the position that the answer to that was no. Obviously, the defendant not. I have set an evidentiary hearing because I felt like we had to have some brackets on the time we would spend on this matter. But I've made no conclusive decisions beyond that on matters affecting the arguments the state makes about the procedural posture of this matter. The next topic would be the burden of proof. Who has the burden of proof in this matter? And what must be shown to meet that burden of proof? And what must then be shown to contest what has been shown and proved? The third topic is procedural defects, most specifically a contention by the state that this motion is untimely because of what was known before a verdict was rendered, accepted in the jury poll. And finally, we need to discuss witnesses, juror witnesses, the clerk of the court of Colleton County is ill, and other witnesses and exhibits. I note that at least one attorney in the room is an attorney for some of the jurors, and other jurors may have other attorneys. When I get to the portion of this discussion where we talk about specific witnesses, and if I am asked to hear from attorneys for the witnesses, I will at least consider that request. I don't know where we will be at that time in terms of what has been decided, but I would at least inquire about that. To that end, if you have not already, during the first break, be certain that all of you, the lawyers participating at council table, and any other lawyers that feel they may have some interest in the proceedings that would warrant comment by them, please give your cards or information about your contacts to our court reporter, Ms. Harris. With that, Mr. Harper, being you are the moving party, you may proceed.
If it pleases the court, Your Honor, you've raised, I assume you want to go in the order in which you just
I would.
Okay. You raised a number of legal issues from whether we waived, a number, I forget the order which you just took them, but Mr. Griffin is going to address those in seriatim based on what you said just a moment ago. As to the witnesses and the jurors, I will be handling that portion of the argument today.
Very good. Mr. Griffin, we'll hear from you now.
Yes, thank you, Your Honor. The first issue that you've asked us to address is an evidentiary hearing necessary? And the answer to that question is very straightforward, is yes, under established case law in the Supreme Court, the Fourth Circuit, and the South Carolina Supreme Court under Reamer. A Reamer hearing is absolutely necessary where there has been credible evidence presented that there's been improper third-party contact with the jury prior to their deliberations that frankly, whether it goes to the merits or not, a Reamer hearing is absolutely necessary. And we believe that the Court of Appeals decision in this case contemplated a Reamer hearing. And in a Reamer hearing, evidence is presented as to what outside influences, if any, were brought to bear upon the jury. We have, in our motion for a new trial, submitted affidavits of one deliberating juror, one alternate, and then another affidavit of a witness to an interview of an alternate, and all three statements are consistent, and in that they heard Ms. Hill, the clerk of court, prior to deliberations, and frankly, before the defense put on their case, Ms. Hill instructed, do not be fooled by the defense. That's what the sworn statements say. And secondly, before Mr. Murdaugh took the stand, Ms. Hill advised one deliberating juror and two alternates, at least, watch his demeanor, which is an implication of, he's going to lie. And so then the question becomes, factually, did those contacts happen? And then, we proceed from there as to what the burden of proof is after that. But the threshold, are we entitled to evidentiary hearing? The law is crystal clear that we are.
Thank you, sir. Mr. Waters, to the state.
Thank you, Your Honor. May it please the court. Your Honor, obviously, you've addressed the issue of whether an evidentiary hearing is necessary. The state certainly understands that. It is incumbent upon us, though, based on the law, to preserve our arguments as to procedural bar, and those are twofold. And the first one, of course, is that a motion for a new trial must be filed within 10 days of the verdict, unless there's after discovered evidence. And I think an initial inquiry that needs to be determined is when the defense first learned of these particular allegations. In conversations with the defense, and they said they're going to give me an answer, that they may have had conversations with juror 785 prior to her being represented, which was only a couple days after trial. So if that is the case and they were aware of these allegations, then we would want to argue to Your Honor and preserve the issue that this is not after discovered evidence and that there's a procedural bar in that regard. Secondly, we made the argument that the affidavits on their face, the only deliberating juror indicated, and that's 630, in that affidavit only said that she voted guilty. She had questions, but voted guilty because she felt pressured by other jurors. And of course, the law is crystal clear in multiple cases that sort of internal debate, it's actually in Rule 606B, that's not any sort of misconduct or anything that is a appropriate venue or mechanism in order to attack the verdict. So for that reason, we've argued that their showing in their motion for a new trial is insufficient based on the case law for an evidentiary hearing, because there is on its face no sufficient allegation of prejudice. That being said, of course, we fully understand and expect the evidentiary hearing to go forward, and we'll be happy to address burden of proof after the defense makes their arguments.
Very good. All right. With respect to, Mr. Griffin, anything in reply?
Your Honor, it does not appear that the state, takes a position contrary that a Reamer hearing is required. They're arguing that we have sort of waived the right to that hearing. There's no evidence of the record of that. I can assure the court, we did not know of this information within 10 days after the trial. And when we learned of it, we promptly acted.
Well, in conversations with Mr. Harpootlian and Mr. Griffin, they were going to actually look into that and look at their paralegal's notes. So I fully rely on and trust the defense to give me a fair answer to that question. And then again, if there's an issue to be raised, we would raise that. We're not conceding anything. We just wanted to preserve our procedural issues.
I don't think we need to go back and forth many times about this. I think I understand your position. Here's my position on the matter. First of all, I am not conducting a Rimmer hearing. Rimmer is a 1954 decision of the United States Supreme Court that deals with the question of influence of the jury and a motion for a new trial on the basis of after discovered evidence of that influence. I rely on the South Carolina decision of our Supreme Court authored by Justice Kittredge, State versus Green. And the Green decision specifically says that Rimmer is not the guidance that South Carolina trial judges should look to in conducting hearings on after discovered evidence. Now, that says nothing about what the burden of proof should be, and I don't intend to say anything thereby. But I do intend to tell you right away that I will be relying on South Carolina's jurisprudence and South Carolina's jurisprudence specifically on what must be proved in a hearing of this nature and who bears the burden of that proof. All right. And that leads to the very next topic that we will now take up, which is the burden of proof. Mr. Griffin?
Yes, Your Honor. As we cited in our papers, we believe that the controlling case in this instance, based on the scope of conduct as alleged, and that is conduct of a court official here in clerk of court, having communication with the jury about the substance or the merits of the case, that the standard to be applied is not Green, because Green, Judge Kittredge says that the contact by the bailiff was about a procedural issue, not about the merits of the case. Here we're dealing specifically with the merits of the case, and the Court of Appeals decision in State v. Cameron, we believe, is the controlling standard. And in State v. Cameron, and that was decided in 1993, and the court says, in citing Holmes v. United States, which is a Fourth Circuit opinion, says in this case there was a private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. When there has been such a communication, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. Now, we strongly believe that is the standard. Is the question of, was the subject matter of the communication harmless and that it could not have affected the verdict? And we are, that's our position on the standard. Your Honor, if Your Honor looks to a different standard, we believe that State v. Green, the measure of State v. Green, you can't look just at Justice Kittredge's opinion. You have to look, because he complimented the Court of Appeals decision. And the Court of Appeals decision absolutely applied the Reamer standard of the burden of production is on the defendant, but when the defendant produces evidence of a substantive communication to the jury by any third party, that's what Reamer is, by any third party, that then there's a presumption of bias, and that the state then has to overcome that presumption, produce strong, clear, and convincing evidence that it was harmless. And that was the standard that The Court of Appeals applied to State v. Green. And in State v. Green, the Court of Appeals says that this is the standard of the Fourth Circuit, and we follow the Fourth Circuit law in this area. Now, Justice Richter says that the communication by the bailiff, which essentially said, if you're deadlocked, which they never were and never became deadlocked, then the judge may ask you to stay locked. I mean, that was the communication by the bailiff in Green, and Justice Richter says that did not go to the merits of the case. Justice Richter didn't throw out the Reamer presumption standard in State v. Green, Your Honor. And it's important, the Court of Appeals decision looking to the Fourth Circuit, because as Your Honor knows, this case, and I would encourage the court to look at the Holmes decision out of the Fourth Circuit, which we cite, which applies Reamer. It applied Reamer in a habeas corpus case when they said Reamer is the clearly established law in the Fourth Circuit. And it vacated a death penalty conviction out of North Carolina because the North Carolina courts did not follow Reamer. And so the Court of Appeals decision in Green says we look to Reamer. Justice Richter says, we're not going to apply the Reamer presumption here because it didn't go to the merits. What we have in this case, and what we have, presented through proffer on the affidavits, something that goes to the heart of the merits. It's the defense. And it's the credibility of the defendant's testimony. And so we do have the burden of production, but we do believe that the standard in Cameron is we just have to show that the subject matter of the communication, that it was material to the case, and that then the burden shifts to the defendant to prove that it was harmless. Excuse me, the burden shifts to the state to prove it was harmless.
Thank you, sir.
That's what we believe the standard is.
Mr. Waters?
Sorry. Your Honor, and I'm going to walk through some of the cases in South Carolina that address this issue. But as Your Honor is aware, of course, when we deal with these issues, we have two types. We have internal misconduct, and our courts have been reluctant. Rule 606 says this as well, to delve into that unless there are concerns of fundamental fairness, like racism and things like that. And then there's external allegations of external influence and that sort of thing. And that's what we're dealing with here today. And to quote State v. Grovenstein, which is a 1999 case of the state Supreme Court, it cites Aldred and Kelly and says, we have consistently held the defendant must prove prejudice in these sorts of claims. And if we walk through all of the case law, our court has been very careful, and as much said so in Aldred, which was an internal case, to sync the analysis and the standards between those two, and have consistently held that the defendant has to show prejudice. It's their burden to do so. In Blake in 1992, the court held don't presume prejudice, and the test, of course, was whether or not the verdict was solely the product of honest deliberation or whether it was the product of outside influence. We go over to State v. Kelly. Of course, Your Honor concurred with Chief Justice Finney's dissent in that case, but in that case, there was a pamphlet in the grand jury room. Clearly, an external influence was alleged there. And ultimately, in that case, the court held that the defendant failed to show prejudice from that particular external influence. In State v. Grovenstein, in this instance, it was clearly external. There was an alternate who was present in the jury room and even took a preliminary vote with the jurors. So clearly an external influence, far more than is even alleged in this case. That juror was removed, curative instruction was given, but ultimately the court was very clear that we have consistently held the defendant must prove prejudice. Again, the burden being on the defendant. In Bryant, this was a capital case, one that argued way back when. And in that instance, there was a police investigation, background investigation into death qualified jurors in a capital case. Clearly external. The trial court conducted an inquiry with questions submitted by the parties as well, and ultimately noted that it was the defendant's burden to prove actual bias on the part of the jury. In State versus Pittman, another case that I argued before, Your Honor, in that particular case, there was a juror who had a conversation with his wife and with the bartender, and ultimately, again, the court held that the defendant failed to meet the burden of prejudice because the wife's comment was the defendant was not guilty, and the comment to the bartender took place after deliberations had begun. And then, of course, in Green in 2020, Your Honor just commented on that, and the court clearly held that the rumor presumption of prejudice doesn't apply here. And then, of course, went on to note that the defendant bears the burden of proving prejudice. And Cameron is a case that they rely on a lot. And I would say this about Cameron, that Cameron, of course, goes on to say that the mere fact of any official communication does not necessarily mean that the jury was prejudiced, and went on again to do a prejudice analysis and a harmless error analysis. Covington is the Court of Appeals case from 2000. In this particular case, there were jurors who supposedly knew the defendant and knew some external information about whether or not he had had previous difficulties with his wife and that sort of thing. Clearly external information. And again, the court held that the defendant failed to show prejudice. So the case law in South Carolina, both from our state Supreme Court as well as our state Court of Appeals, is clear, it's in sync, it's uniform, that is the defendant's burden to show prejudice. And that's, of course, only after there's a determination that any sort of extraneous influence occurred. And that would be the state's position, that it is the defendant's burden. And again, we can address at the appropriate time what the state's position is as to the order of which the evidentiary hearing should go.
Thank you, sir. Mr. Griffin, in reply?
Yes, Your Honor, there is a tremendous difference in the law as to how the court analyzes juror misconduct, as in Kelly, where the juror reaches out to her pastor, gets a pamphlet, brings it into the jury room, and that was found during the course of the trial. The trial judge removed juror O, who had gotten a pamphlet, ordered every juror to ask what effect that had and if they could put that out of their mind and then deliberate. So that happened during the middle of the trial, but it was juror misconduct. All the other cases that he cited and the state relies upon are juror misconduct cases. Not unauthorized third-party communication that goes to the heart of the Sixth Amendment, right by a defendant to confront his accuser, to cross-examine witnesses who present evidence. When a third party makes an improper contact with the deliberating jury before they deliberate, that falls at the heart of the Sixth Amendment, which is a different animal altogether than where a juror engaged in misconduct. And that's where you get to Cameron. That's where you get to Green, which Green says it was a procedural communication, not a marriage communication. And Your Honor, in Bryant, well, I would note, Your Honor, dissented in Kelly, but in Bryant, I mean, no jurors were interviewed, as best we could tell by the record. But in Bryant, it was a death penalty case. Law enforcement, I believe in Horry County, were out questioning the jurors' relatives and friends and trying to get their belief as to whether they believe in the death penalty. Apparently, some of that kind of leaked back to one juror, or maybe, but there was no record saying the jurors were prejudiced by that. But the court said that behavior cannot stand, and we find prejudice based on the conduct, not on the juror's testimony. And they didn't use the word presumption, but they found prejudice. And I don't want to get caught up in this issue of do we have to establish prejudice? I think prejudice is established, but the question has to be established. But the question is it presumed under the circumstances? And if it's presumed under the circumstances, what does the state have to rebut it? And so, prejudice is a touchstone, but the question is evidentiary presumption. Here, where there's a third-party communication that goes to the merits of the case, the law is crystal clear that there is a presumption of prejudice, and the state has the burden of proving it's harmless beyond a doubt.
Thank you, sir.
Thank you.
All right. Mr. Waters? I'm not going to go back and forth a million times. If you want to have a short comment and additional comment.
Very short, Your Honor. He said that these were not external influence cases, and every one of them that I listed was, Your Honor. Blake was a bailiff. Kelly was a pamphlet. Again, it was an external piece of information coming in. Grovenstein, it was an alternate. Again, that's an external influence. Bryant was a police investigation. Pittman was a bartender and a wife's comment. Green was a bailiff. And Covington was, evidence that was not admitted at trial that the jurors were aware of. So clearly, all of those were external influence cases, Your Honor.
All right. I do not regard State versus Cameron as the guidance that needs to be used by me in making a determination about this case. It's a Court of Appeals case. Since that case in 1993, there have been several cases, including Green, Oliver, and others, that very specifically talk about this issue of what the burden is when a motion for a new trial on the basis of after discovered evidence that involves tampering or alleged tampering with the jury. All those cases say that prejudice must be proved, not presumed. And it may very well be that that is what's going to be shown. But for purposes of what the defendant must show as the case goes forward to an evidentiary hearing, the presumption simply by the contact, which we don't have any sworn evidence about except in the area of one juror at this time. A presumption is not the way to examine this issue, but rather specific evidence about what was said, when it was said, and how it was perceived by the juror is what I believe is required by State versus Green and other cases. And therefore, that is the approach I will take. All right, the next area of inquiry is the procedural argument of the state that this matter was untimely made. Mr. Waters?
Yes, ma'am, Your Honor. And again, we have raised the issue, as I talked about earlier, that we believe that there is at least an inquiry as to a procedural bar, that if the defense was aware of these allegations during the 10 days, then it is not after discovered evidence and the motion is untimely. And additionally, we also, as I previously expressed, have raised the issue that the affidavits on their face are insufficient to put in play an evidentiary hearing. And there are multiple cases that have in the state that have held, I think Yarborough is one of those that have held that where that showing was not made, that the trial court properly denied an evidentiary hearing. So we would just preserve those issues, understanding the court's plan of procedure that you previously expressed.
All right. Mr. Griffin or Mr. Harpootlian, let me say that I will say to the defense, to the state, I believe that issue needs further exploration, so I am not prepared to rule that this matter is untimely in the least. We're going to have a hearing on this matter, at which time this issue will be further explored. So the state has preserved its position, but you need not argue about that matter at this time.
Thank you, Your Honor.
And now the matter that to me is the heart and soul of what we're doing today is the witnesses, the exhibits, and the procedure needed with respect to the witnesses. And the witnesses, at least, are the jurors and the clerk of court, Ms. Hill. What I'd like each side to explore with me is how those witnesses should be presented, who should present them, and how they should be questioned, and whether there are any brackets or limitations that should be imposed on what these witnesses are asked. And I will begin with the jurors, which is really the heart and soul of the matter. Other witnesses are very secondary to the first issue, which is the jurors themselves. Mr. Harpootlian, you are the moving party, and you may proceed.
Your Honor, we agree all 12 jurors should testify. I think both sides agree, Your Honor, it's a question of jurors. The only question is, not only question, but the first question would be, as Your Honor questions these jurors, would you, in all the cases the judge questions the jurors, Would you want suggestions from us as to what additional questions after they respond to your questions, that raise additional questions? That's number one. Number two, each one of these jurors, except of the original 12, I think all have been interviewed. Maybe 2 have not been interviewed by SWED and given statements, recorded statements. The rest have all given recorded statements. And then SWED prepared a memorandum of interview. We have reviewed all these videos and the MOIs, and I can tell the court that the MOIs aren't consistent in many instances with what was said on the video, to the extent that information was left out. Now, if Your Honor is going to be very restrictive and ask, did the court communicate something to you, and did it affect your decision? I guess that's what we're hearing, Your Honor, when you're following State versus Green. If you're going to say that, ask those questions. I mean, there's some of these jurors who indicated they heard the court say what the juror that gave the affidavit for us say, and I think they're going to say it didn't affect them, which is fine. If it affected that one juror, we believe that's enough. And that juror has obviously given an affidavit to us. The alternate, which was excused, and we keep calling her the egg lady, but she was also excused. The alternate because she wasn't needed, the egg lady because the judge found that she had contact with people and discussed the case. They further indicated that the court said what we say she said, and we believe they should be examined. We'll be happy to do that, or the court can do that. So there are witnesses, and then we have the court herself. I talked to her lawyer this morning, who indicated she has not made a decision as to whether or not she would assert any constitutional right not to testify. And obviously that would be on a question-by-question basis. Maybe, I don't know, I mean, we're not ready to argue what the standard is on the Fifth Amendment this morning. But if she does testify, there are literally thousands of emails we were furnished last week by Colleton County, some information furnished by SWED this morning and the Attorney General, which might be utilized, I can't say right now what it would or wouldn't, depending on her answer, to impeach, to contradict. So I can't tell you what exhibits it would be or what we would do because I don't know what her answers are going to be. We believe we should be able to examine her as a hostile witness. We should be able to call her as a witness because the burden is on us, as Your Honor just enunciated. Now, the only other thing I would say is this. Even if Your Honor determines that a piece of evidence or a question is not admissible for your consideration for purposes of the appellate record, we believe we ought to be able to make a proffer. So it may be that Your Honor allows us to go forward, and then in your decision decide it's not relevant, in your decision decide you didn't consider it, or whatever. But stop and go is going to elongate that hearing dramatically. And again, since you're the finder of fact, you can decide not what a jury is going to hear, but what it matters to you. So we think that the examination of the court should be wide open, and we think that the exhibits we would use to impeach her, we would attempt to keep it relevant to the specific issues in this case. I mean, her son has been indicted, for instance, her son's been indicted for wiretapping. There seems to be some inference, at least what we read in the papers, we don't have any specific knowledge, that she was aware of that and that wiretapping was in relation to some ethics complaint about her. That's not relevant. We're not going to ask her about it. Now, we're continuing to examine whether or not there is some connection there, and we're investigating that. But at this point, I would tell you that's not where we're going. Where we are going, by by way of example, is we have been furnished an email that she got on February 24th from somebody, which was a photo, a screenshot of looks like a posting on some sort of Facebook page, where the ex-husband of a juror, not the egg lady, alleges that his ex-wife has been talking about the case and she is going to vote guilty because she hates men. Now, we know she got it. We know she got it on February 24th, yet on the morning of February 27th, she tells in the chambers, the hearing we were all present at, that she had seen a Facebook page posting by egg lady's ex-husband alleging that she was talking about the case and she didn't think he was guilty. That Facebook page had never been produced, and then she produced a Facebook posting, she said, by the egg lady's husband. Turns out to be a guy I interviewed in Georgia, apologizing for what he had posted on Friday night, which concerned his wife's aunt meddling in their marriage. I think that's fertile ground for cross-examination. Your Honor may disagree with me, but I still would like to put those items into evidence for the appellate record at the time. The last thing I would say is this. In terms of Your Honor questioning the jurors, we need instructions from you as to whether you want, if you finish with the juror, do you want us to submit questions to you? I doubt you're going to let us question them. How is that process going to work? And will that be done someplace? Will it be done in this courtroom? Will it be done somewhere else? And if the jurors are going to be questioned outside of this courtroom, will there be a way for the public to hear what they have to say? Thank you for your indulgence. Mr. Griffin rightly points out, it's not just what they heard, may have heard from the court, but did any of the other jurors, for instance, egg waiting, if you call her, gave an affidavit indicating Becky said things like, don't be fooled, watch the body language, watch the body language testifies to Mr. Murdaugh. Did she relay that to any other jurors? It's not just what, I mean, did the sitting juror or the alternate in the one other point, in the memorandum of interview, now, the Cork's private lawyer, Mr. Lewis, objected to any videotaping or audio taping of the Cork when she was interviewed. But in the memorandum of interview, that is, the Cork indicated she had conversations with the four-lady outside the presence of the rest of the jury about what was going on in the jury room. Obviously, I would cross-examine her on that, but it may be necessary if she testifies to things that are inconsistent in that MOI for us to call the sweat agent that did the interview to corroborate the MOI. The MOI may be introducible in and of itself as an exception to the hearsay rule, but I believe it may be necessary for us to call the sweat agent. We're not going to, and Your Honor, we're not you've indicated that you're not gonna want any sort of summaries of those interviews about the jurors, when we talk back in chambers, or necessarily the MOIs. You want your own fact finding with the jurors. To the extent that they contradict those, we may put all of that into the record for appellate purposes. And if you want to see those before you have this hearing, we obviously put those in the record today, or have those available to you, both the MOIs and the videos. We're obviously, we're going to do whatever you tell us to do, but we're looking for some guides as to if there's anything we can get you prior to that evidentiary hearing concerning those memorandums of interview by the SWED agents and the videotapes. Whatever you instruct us to do. Thank you for some indulgence, Bill. Your Honor, you mentioned, and Mr. Griffin reiterated to me just now, and obviously you don't need to tell us this today because we're not going to be doing the questioning, but there is the consideration of 606B and the incursion into deliberations. At some point, we don't need to know that today, but at some point prior to you questioning the jurors, we'd like you to enunciate what your position is on that.
You're going to have to outline that a little bit more for me. What part of 606B are you discussing?
Well, it says, if I can find my glasses. Upon an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or any other juror's mind as or emotions as influence a juror to assent to or dissent from the verdict.
All right, so and what are you saying that imports for this proceeding?
Well, I mean, for instance, if we show you, we prove to you that the court said, do not be fooled, or, watch Murdaugh's testimony, watch the body language inferring he was lying, he will be lying. One of the issues is if the juror who sat during the deliberations who said that the court said that, did she discuss that with any other jurors? Did she infect the jury? Does this allow you to do that?
Well, you certainly, if you go to 606B, it gives you some guidance about that. It says, upon inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or any other juror's mind or emotions influencing the juror to assent or dissent from the verdict or indictment or concerning the juror's mental processes, except a juror may testify on the question whether extraneous, prejudicial information was improperly brought to the jury's attention, or whether any outside influence was improperly brought to bear upon any juror, nor may a juror's affidavit or evidence of any statement by the juror concerning a matter about which juror would be precluded from testifying be received for these purposes. I take that to give us the guidance we need about the parameters of the questions.
But if the juror that gave us the affidavit, would she be asked, did you discuss that during deliberations? Can she do that?
That apparently is very questionable under the terms of 606.
Yes, ma'am.
And I intend to abide by that. The way those questions have been asked in many cases I have reviewed is to ask the juror whether that's still their verdict. If they asked about improper contacts and they talk about improper contacts, then the way to pursue it beyond that for the judge is to ask about the impact on the verdict, not on the deliberations themselves. That may be a small slice of difference, but I think it's very important to understand that no one, not myself or anyone else, is going to be asking the jurors about the specifics of their deliberation, and the rule is quite clear about that.
Okay. And is it clear that you will not be using the SLED interviews or MOIs to attempt to impeach?
I told you when that was brought to my attention in our Chamber's conference this morning, I haven't made my mind up about that. I don't know what's in those summaries or anything else, and we're going to have to discuss that. But again, I'm the one doing the questioning at this point, Mr. Harper.
Yes, yes.
And I'm trying to perceive what you all are asking, and I'm going to go to the state now and see what their reaction is to what you said.
Thank you, Your Honor.
Mr. Waters?
Thank you, Your Honor. May it please the court. Your Honor, again, we would concur with what Your Honor just said about Rule 606 and, of course, all the cases that we've talked about, and the need to show prejudice. And obviously, when you're talking about external influence, that prejudice, which will be an appropriate subject of inquiry to the jurors, is whether or not there was an impact on the verdict. And we, of course, have suggested to Your Honor, not only based on the cases, that should be judicially conducted in a manner that protects the privacy of those jurors and it protects the privacy of their identities. These jurors, were drafted into service, and this inquiry, of course, has to happen, but it needs to be conducted in a manner that respects their privacy and should be, of course, judicially conducted. We have suggested those two questions. If we look at the Bryant case specifically talked about the fact that depending on how the examination goes, there could be questions suggested by the parties. And obviously, I think we would need to cross that bridge if and when that bridge needs to be crossed. And that starts with the court's inquiry to those jurors, and only if something arises that needs further inquiry could that be addressed at that point. And that could be even a discussion from counsel with the court as to what additional questions may be proper. When the state first became aware of these allegations, the first thing that we did was have SLED do an independent investigation, and the goal was good, bad, or ugly to get to the bottom of what, if anything, happened. And the result of that is why we're still here today. And that is that in speaking with the jurors that spoke to us, that the balance of the evidence, as well as in talking to the clerk staff, was that there was no impact on any verdict. There was nothing unprofessional or untoward that happened that had any effect on the verdict. And so when we did that inquiry, and that is what the jurors said, that is why we're here today, and that's what this hearing is going to address. The only juror that we have is the one who filed the affidavit. That's 630, and even she, or that person, only said that she, eventually voted guilty because she felt pressured by the other jurors. Did not even mention any external impact. And so unless she's going to change her story, that is what was in her affidavit. So the balance of the evidence is the reason why we're here today and why this hearing needs to take place. Your Honor, as far as inquiry to those jurors, again, there could be a need that the parties would suggest questions, and it could be, depending on how things go, that the affidavits or maybe even the recordings, all of which have been provided to the defense, the full recordings of those interviews of any potential witness in this case have been provided to the defense. It could be that issues could arise from either the state or the defense as to impeachment, and we can address those issues as they arise under the appropriate rules, 608, 613, and the like, dealing with not only prior inconsistent statements, but other evidence that would be properly impeachable. Ultimately, I do need to address one thing as it deals with all of this, and that is the defense's contention that somehow the clerk is a party opponent in this particular case, and we believe that that is incorrect. Obviously, there is a hearsay exception or a non-hearsay determination in the evidentiary rules, I believe in 801, that excludes statements of a party opponent. But just because the clerk is an elected official of the state, that does not make them a party opponent in the way that term is defined. A party opponent is an active litigant before the case, and that is, I think, different. So we would certainly say that the hearsay rules would still be in effect as it relates to Ms. Hill and any testimony that she may provide. I know there's been some discussion about the order in which the witnesses may be called and whether or not Ms. Hill would be a hostile witness. And obviously that's under Rule 611 and I believe C, which would allow leading questions, if a person is hostile. I think, again, at this point, I don't know that any showing necessarily has been made, but I understand the defense may raise that point, and we may have some arguments at that time. But I don't know that there's been such an identification between Ms. Hill and the state that would allow, A, her to be identified as a party. I think that's far out of bounds, but also that she would be applicable to allow defense leading questions under 611C. Your Honor, in looking at the type of examination that would need to happen here, and again, the issue also arose of the Fifth Amendment. And I know that the defense would like to brief that issue, and we're happy to respond. We don't know exactly how that might arise in the course of any examination. We need to cross that bridge again when we get there. We would say, though, that the Fifth Amendment is question specific. And so, again, it may be something that this court has to rule, as is in any sort of evidentiary presentation, question by question, based on any objection by the party. So it's kind of hard to say that exactly what a blanket position would be until we actually get to that determination. Ultimately, the defense referred to some information provided this morning. Actually, both sides exchanged last night their communications with the clerk during the course of the trial. So both sides did that last night. And there were a lot of communications with the defense as well. And so, again, I just want to point that out in that there's any sort of allegation or insinuation that the state's not providing information. We've been very diligent about providing any and all information to the defense. And if any additional information arises, we will continue to do so. But both sides exchanged that last night. And of course, there's been some reference in their filings as to emails that were forwarded from the clerk to me and to my paralegal. And they've actually even listed me on the witness list. And Your Honor, as we have had a chance to peruse the defense communications with the clerk, there was just as much communication and offers of help. It was just a uniform across the board courteousness that's reflected from those. So we think that that's a non-issue, and we think that should not be something that arises during the course of this evidentiary hearing, at least as it would require communication from or testimony from attorneys. Your Honor, ultimately, as we look at the inquiry that will need to be conducted, as the state has made clear, it starts with the jurors. And only if something arises in that inquiry, further inquiry to those jurors may be necessary. And that could be in discussion with the parties, as I've stated before. And then I know Your Honor has indicated the clerk should testify, and we certainly understand that. The clerk filed an affidavit denying any of these allegations. And so, again, as we address the clerk's testimony, the state would have objection to some of the information I believe the defense would propose to examine her on. We believe that an inquiry should be limited to what is appropriate and relevant impeachment, but not should be just a far-ranging fishing expedition or full come up since the trial that we believe are not relevant to any inquiry that is before the court here now. Obviously, rules 404, 401, 402, and 403, as well as, which of course address relevance, and 403 objections, 404, which addresses other crimes or wrongs or acts, rule 606, or excuse me, 608, which addresses inquiry into other specific acts and impeachment, and rule 613, which talks about prior inconsistent statements. All of those rules potentially could come into play depending on the nature of the testimony and the nature of the inquiry. But there have been allegations since the trial about the book, about this wiretapping case, about investigations into alleged use of office for improper gain. But again, all those are subsequent to the trial. And so again, depending on how the testimony goes, the state would raise appropriate objections at that time to limit the inquiry to what is appropriate for what is before the court we would submit. And that is what occurred during the trial. So we would make those particular evidentiary objections as things developed. Ultimately, that would be the state's position. I know that we're trying to put as much meat on the bones as we can at this particular point in time. But I think the reality is that the court's inquiry to the jurors will really determine the nature of the inquiry that needs to proceed from there. And at that point, the state would take the positions that I've outlined here today.
You reply.
Please, the court, Your Honor. 404, I find it somewhat ironic, state is quoting Rule 404, Your Honor. One of the exceptions to 404, I know this would be surprising to Mr. Waters, is motive, as if you've never heard that before. He told me this morning one of the assistants that worked for Ms. Hill during this trial was told by Ms. Hill during the trial that a guilty verdict would be good for sales of the book. Motive, selling books. So we believe we should be able to get into that. We should be able to ask Ms. Hill about it. If she denies it, to call that witness, that assistant, and have her testify that she was told that. I mean, why would a clerk do what we allege she did? We think is important for Your Honor in terms of credibility and context. That's number one. Number two, Your Honor, I think we've all agreed, you're going to ask the questions, whether we agree or not. And we do agree with that. The question's going to become, as we go through that process, how, if a juror says X and they've said in their interview Y, or if they've said to us Y, or didn't include it in their original affidavit, and you don't ask that question initially, how are you going to handle, or do you care, how we suggest to you a further question? Because as Your Honor's seen this morning, the back and forth can go on for a while, and we certainly don't want that to go on with a juror. So we're going to need some guidance on that. I'm not expecting that guidance this morning. The last thing is, as these jurors are examined, I need to understand a little bit about the logistics. Are we going to do it in this courtroom? Are we going to do it in another courtroom? Is the public going to be able to hear the responses? Will there be an audio feed if we do it somewhere else? Are you going to have cameras turned? You can do it in this courtroom, have cameras turned off? And we're obviously not going to refer to jurors by their names. Even though 3 of these jurors went on the Today Show, another one went on ABC. They were all in the courtroom when the judge had them brought in. They were in the courtroom, all except one of them, for the verdict. Cameras were there then. Again, I'm sensitive to their anonymity, but I don't know that any of them have any real anonymity anymore. Saying that, I think it's important not only for Your Honor to hear their answers, but for the public to hear their answers. Thank you. Thank you.
All right. With respect to the jurors first as witnesses, I will be doing the questioning of the jurors, and I will notify the parties pretty promptly what I intend to ask the jurors. The ambit of what I will be asking them is informed by the question of whether improper contact was made with them and whether it affected their verdict. I understand that you, on the defense side, have views about what further should be asked of jurors on 2 levels. One, as a predicate to what you want to do with the clerk herself in examining her. And 2, as a means of further attacking the credibility of the clerk in her testimony. I have not seen any of the SLED material or memoranda concerning the state's summary of these interviews and so forth. I will be open to receiving that if it's done promptly, because we've got a hearing coming up the 29th, and I want there to be plenty of time to revise any current ideas about who to subpoena, who to call as witnesses, and who has to do that. But I can tell you that I am very, very reluctant to turn this hearing about juror contact into a wholesale exploration of every piece of conduct by the clerk alleged to have been improper on its own, indicative of her characteristics or personality or anything of that nature. This is a very focused inquiry that deals with this jury and what impact contact, if any, had on this jury. So I am very mindful of the limited nature of it. As I say, I'm not excluding submission in advance of information that would take the questions beyond the limited questions I've initially indicated. But I will be at any of those questions as it involves propounding those questions to the jury. As it involves questions to Ms. Hill similarly, this is not a time to explore every mistake or incorrect statement or false statement that ever has been made by this witness. I am the judge of the credibility of this witness for purposes of this new trial motion. I don't think it's necessary, nor do I think it's proper, to explore each and every impropriety alleged to have been committed by the clerk. At the same time, what specifically should be asked is something that I will look at as I look at the submissions that are made before the hearing takes place, about what is requested to be allowed as topics for questioning of the clerk and what exhibits should be used. I can't imagine allowing thousands of emails to be made exhibits in this process, either emails sent by her to attorneys in the case, to other court officials in the case, individuals during the course of the trial of the case. I certainly will try to preserve the appellate posture of defense in this regard, but I will put certain limitations on just a wholesale exploration of every problematic piece of conduct, ethical dealings with the county, and so forth. This is a very focused inquiry about this jury and its ability to render the verdict it rendered in an impartial manner. So I say that to tell you that when the clerk is offered, and I think the clerk is going to have to be offered as a witness, the whole allegation revolves around the contention that the clerk made contact with the jury about matters material to their verdict, that contact was improper, and that it impacted their verdict. There's a whole lot more that Mr. Harpootlian has indicated he'd like to explore that I regard as totally extraneous to the inquiry that we maintain. I'm not going to allow those questions to be asked by way of proffer and then have the clerk answer those questions and have that be the proffer, although I consider them irrelevant questions. We're not going to handle the case in that way. If I exclude a certain question from being asked, then the proffer will be whatever in writing is chosen to be offered in that regard. But I will not conduct a hearing where there's a whole side hearing in which every question desired is asked and either required to be answered or dealt with in some other way. I don't think that is an appropriate use of this very targeted hearing that I'm directed to have. I also think it makes a great deal of difference whether the questions that are being asked relate to the clerk's conduct at the time this case was tried, as opposed to other conduct at a later time or in connections with other things than the trial of this case. So I will be looking very carefully before we conduct this hearing and trying to give the parties as much advice as I can about what I would find to be acceptable topics to pursue. I think you're entitled to that, but I also think the record of the case is not to be used as a platform to explore each and every fault of each and every witness, whether it be the juror or the clerk. And I'm not going to have the hearing conducted in that manner. I think there are other ways of preserving topics that I rule should not be pursued than having those questions asked and answered, even though I ruled that they are not proper in the hearing. So I hope that explains kind of where I am on the subject of how questions are asked. And therefore, some of the suggestions that are made in the filings you've made with me about the additional witnesses you'd like to call and subpoenas, I think to be sure we're all on the same page about what is acceptable in evidence and what is not. But I can tell you that I would not allow the subpoenaing and examination of attorneys in this case, of the judge who heard the case, or any of those type of witnesses. This case is very focused on the jurors and the clerk of court, as I see it. Now, it's about 11:15, close to it. I'm going to do this. I'm going to take a break for a minute. Let's take until 11:25 as a break. And in that time, I would hope that you formulate the other things you think we need to look at by way of the specifics of how this matter is to be conducted. I will then do two things. When I come back and ask you for further ideas, both sides, as to who should be called, get very specific about who can be called and who cannot, who should offer these witnesses. And I would also at that time ask those who represent potential witnesses in this matter to come forward and have a conversation with me about your position on behalf of your clients. I think that's particularly important because as we have the actual hearing itself, I've never heard of a situation where a witness can have their lawyer actively participate in the examination of the witness in a proceeding in which the witness is being offered. So I would not allow that, but I think we can protect the legal positions that attorneys for witnesses want to take and need to take and want to put on the record by pursuing in the way I've just outlined, and I'll be prepared to do that when we return. All right, court will be in recess.
Thank you, Your Honor.
Thank you, Your Honor.
Before we proceed further, a few other things that you've asked about that I want to clarify before we then go forward with a more specific look at how witnesses will be questioned. First of all, how the jurors will be questioned. Everything will be done in open court. The jurors will be referred to by number. The court TV cameras, which are the ones used to film these proceedings, will not be allowed to focus on the image of the jurors as witnesses. And if there's some need to further obscure the way they are presented, we can talk about that. But they'll be examined right here in the courtroom as other witnesses would be. And I kind of looked at a little bit of exchange we'll have with attorneys for the jurors to see what we can work out about exactly how the jurors are presented. But everything will be on the record here in open court with measures taken to ensure the privacy of the jurors. No photographs would be permitted of the jurors or anything of that nature. And I believe if I announce that in advance, the press that are present, the press that have covered this proceeding throughout have been respectful of the judge's requests, and I'm very confident they will be in this matter as well. With respect to the alternate jurors, I will question only the jurors who sat and considered this case. So the alternate who was dismissed by the trial judge. That alternate did not participate in any way in the deliberations about this case. There's nothing that's been brought to my attention about anything the alternate might have done that was improper at all in terms of communications with fellow jurors. Nothing's been alleged in that regard. So our focus will be on the jurors that heard this case and not on either that alternate or any other alternate juror that has been proposed for questioning. I will not permit that. With witnesses or testimony, I do not allow. Let me explain about proffer. Proffer will be a written proffer by the party dissatisfied with the limitations of my ruling. But there will not be some examination as to proffer. The proffer will be a written proffer by the attorneys in accordance with their positions about witnesses and testimony. With regard to the subpoenaing of witnesses, the parties should subpoena these witnesses. And when it comes to the jurors, I would urge that the parties, the state and defendant, jointly deal with the issue of subpoena of these witnesses. I do not think it is the court's place to subpoena witnesses or order witnesses' appearances. This case is driven by the parties and their positions. The initial position of defense was that only certain jurors should be called. The state said no jurors should be called, but if you do, all should be called. All who sat on the case should be called. If the parties can't agree on how that subpoena should be accomplished, then I'm sure they'll let me know, and I'll try to take some measures in that regard. The concept I would have is that the jurors would report to a place that I will specify, and when they report, they would be taken to a room with appropriate supervision by court personnel, and then called individually to recite their testimony. And then when their testimony was complete, they would simply take their place in the jury box until all were questioned. And then if there were any questions further by me that would be collectively made to the jury, I could do that. And if there are any further questions that were submitted to me by the parties that I chose to question, I would do that. And then when all of that was complete, the jurors would be allowed to be dismissed. So that is how I would handle the juror witness portion of this. And of course, I know I'm going to get some commentary from each side about that. That's why I talk about this in advance. The other witness that surely needs to be called because of the allegations made is the clerk of court. The state has submitted a preliminary affidavit by the clerk of court, and the defense has many areas that they want to explore for the court. Again, I would like for the parties to develop some joint way of subpoenaing the clerk of court. And if I need to be a part of that, then I'm sure the parties will let me know. But I say this for the benefit, particularly of the attorney for the clerk of court, to know that I would expect that the clerk of court will be called as a witness in these proceedings, 29, 30, and 31 if necessary. We'll be using the same courtroom for these proceedings, this courtroom. And 3B will be used as an overflow for the press. Excuse me, 3A is the one over here, and that's the one I'll be using to conduct the hearing. This courtroom we're sitting in now will be an overflow courtroom for press with I'm sure, a court TV monitor that's available for them to monitor the proceedings if there's not enough room. Based on the attendance today, it might be plenty of room, but we'll see. We'll have this as, I will try to figure out a way to be sure that the broadcast in here of the proceedings will not interfere with the conduct of the hearing past this partition next door. I will trust Mr. Bender to work with the press to arrange the courtroom and the overflow room in accordance with the rules I set forth here and anything else that may come up that needs my attention. I think that covers it at the present time. So the first thing I'd like to do is to get some clarity from the attorneys as to what furthermore, for the parties, as to what furthermore needs to be discussed. And then after that, we'll explore with the attorneys for the jurors and the attorney for Clark Hill any other issues that still need to be developed. Mr. Hopwood.
Please support, Your Honor. I'm trying to make sure I understand what you just ruled. Are you ruling that we cannot call the alternate juror or the so-called egg lady to corroborate what was said to the sitting jurors since they were all told this at the same time?
I'm not sure I understand your question, but I'm telling you that I want these jurors, these alternates would be called apparently to testify as to what the clerk said.
Yes.
At the present time, I see no necessity for them to be called to say what the clerk said because we're talking about what the clerk said to the remaining jurors, those who actually sat on the case. The corroboration is something I don't think I need at this time. I think I'm perfectly capable of evaluating what the jurors tell me, and I'll do that. I think I'm also perfectly capable of evaluating the credibility of Ms. Hill and the jurors for that matter.
Well, Your Honor, for us to, and then you said you wouldn't allow a proffer of that except in writing. Now,
yes, I'm not going to have a courtroom proffer of any kind. If you want to proffer what would be offered by means of affidavits, copies of emails, anything else you want to, that's fine. But I am not going to have a courtroom proffer, no. I think the only reason for the proffer would be to preserve your right to appeal. I believe your right to appeal my rulings would be perfectly preserved, frankly, even if you didn't have a proffer, but even more so if you supply an in-writing proffer.
Well, I'm trying to determine whether an affidavit is sufficient for an appellate court, federal or state, when the state won't have an opportunity to examine that witness. But I mean, they've given, I mean, we can get more detailed affidavits. You know, these people are witnesses to what the clerk said to the juror who deliberated. I don't understand how that can't be relevant to Your Honor's decision. I understand there's two steps. One, did she make the statement? And two, was it prejudicial? These witnesses corroborate she made the statement.
Well, of course, that's what you say. So far, I haven't seen any of that. If that's what you say and you offer it to me in some form that I can evaluate it, I may revisit that decision. At the present time, but at the present time, I see nothing that prompts me to think I need to have people who did not sit on the case talk about what they think the clerk said to other people when I've got to direct people to who it said that I will question.
Well, Your Honor, we did submit an affidavit, but I have no problems going back.
You submitted one alternate affidavit
Right.
and one affidavit of a dismissed alternate. I'm aware of that.
Right. So.
And that doesn't prompt me to change what I've just said to you.
All right, we can get you more specific. I understand what the questions are you have, and I would only put those folks up to deal with those very limited issues that you described. Put them up in 10 minutes.
Well, again, I'm not going to rule in a vacuum. I'll see what you say, and I'll rule upon it.
We'll get affidavits and file them with the court.
Very good.
Thank you.
Your Honor, just one issue as to logistics. Obviously, these jurors are down in Colleton County, and we're up here in Richland County. I've spoken with SLED, and in as much as we need, there may be jurors who need transport. SLED has certainly agreed to have 12 cars if we need to make sure that they're individual. They can then come in through the garage, and obviously they'd be brought up to a jury room. I think Your Honor indicated they can be in a jury room with a bailiff in there to make sure that no one's talking about their testimony and that sort of thing, but also so that they don't have to come in through the public entrance and that sort of thing. So that would be.
I think that would be a good solution, and of course, to satisfy the concerns that the defense may have, you could either have a member of the defense team or one of their employees ride with them, or if you could agree upon a sworn statement by the agent or person that does drive them that they, A, will not say anything, and B, did not say anything, then that may cure the problem too. I think you all can work that out. I do think having proper transport would, first of all, be a comfort to the witnesses themselves, the jurors themselves. But if they can arrange something otherwise, of course, they'd be free to do that. But to the extent it's a burden on them, yes, I think that's a good idea. And in all events, I would want arrangements to be made to have the jurors come to the parking garage in this building and be escorted up in a private way into their assembly room.
And yeah, absolutely, Your Honor, and we will, and I'm sure SLED, I've already spoken with them about that, have uninvolved agents who will be under strict instructions not to discuss the case, and happy to have them sign affidavits or whatever to that
Very
effect.
good. All right, anything further before I go to the lawyers for the jurors? All right.
Your Honor, only one other point, and that is you asked us to give you exhibits that we would use.
Yes, sir.
Having not asked or had the opportunity to ask Ms. Hill a single question, I can't tell you, in terms of, there's not thousands of emails we've used, probably 5.
I'm just going on some of the descriptions that were in the filings y'all have made to me.
Well, we've received thousands of emails from Colleton County, based on a subpoena we issued. We've received hundreds of pages from the AG's office and from SWED.
It'll make it a lot simpler if it's a small number and a discrete number, submitting them to me. Again, I told you I would evaluate that when I get them.
Of course, I don't think you can evaluate them until she testifies. You know,
I think you're gonna have to trust that I am gonna do some evaluating before she testifies.
Okay, and Your Honor, you know, she's given an affidavit denying making any of these statements.
She has.
So these alternate jurors that have been dismissed, would you allow us to call them to impeach her if that's what she testifies to?
At the present time, the answer to that is no, as I have indicated. But again, I'm not gonna rule in the vacuum. I would hope that what you all will do is send me a pretty specific idea of what you want and how you want me to permit it. So I'm not gonna rule on something I haven't seen yet, which is your proposal as to exactly how these witnesses and alternates to be used.
All right, we'll get more extensive affidavits from those two alternates.
Oh, okay. That's fine, or descriptors of some sort from you as to what you intend to do. I'm not gonna dictate how you do it, but I'm gonna have a lot more than just kind of the generalities that have been discussed in these briefs in order to permit.
Well, I think we're gonna need an affidavit for appellate purposes, nothing else. I mean, my description to you is not evidence.
Oh, I agree, but you know, again, I will tell you how I'm gonna accept the proffer. What you put in the proffer, in the written proffer, is up to you. I don't want to dictate that or manage it.
Well, I just want to say that we're going to hopefully be able to get affidavits from these folks.
Yes.
Much more descriptive than the original affidavits.
Oh.
Thank you.
Oh.
Your Honor, may I consult with counsel very briefly?
Certainly.
One of the things that was discussed earlier was the independent SLED investigation that was done. There were recordings of some of these interviews and MOIs prepared and that were just meant to be summaries. I know Your Honor mentioned earlier that you would be open to receiving those.
Sure, I'll be glad to review any of that.
Discussed that with counsel, and I believe they said, well, we want to send the ones we want to send. I think if Your Honor's amenable to that, we would just add Your Honor to the discovery upload that was provided to the defense so that information is available to the court for whatever purposes the court deems necessary.
Can I ask this?
Yes, ma'am.
First, would that discovery upload include your interviews, the tape of the interviews, as well as your summary of them?
Yes, ma'am.
All right. I will ask you to let my clerk, Eva Diaz, talk with you afterwards about how to send me something of that volume.
Sure.
Our court, IT has a lot of barriers in our system to us receiving even conventional websites and web tools for examining in volume documents. And so I will want her to interact with you all about exactly how I am to receive that material. But yes, I would be happy to receive it.
And we would be happy to get a couple of flash drives and provide it that way, if that makes sense.
That might be the better way to do it, because again, I can very easily examine a flash drive, even though it takes a long time. Typically, you are kind enough to provide an index at the front of the flash drive as to where the various materials are located. That might be better than using one of these web document sources, since so many of them are excluded from our system.
All right. Well, we'll prepare one and have a copy for you, Your Honor, and then for Ms. Diaz, the clerk as well. Thank you.
Now, on my list, I have in the courtroom at this time, Mr. Bland, who represents certain of the jurors, Mr. McCulloch, who represents certain of the jurors, and Mr. Lewis, who represents Ms. Hill. Are there others in the courtroom who represent jurors or Ms. Hill?
But Your Honor, Ronnie Richter on Mary Blaine's partner.
Went a little fast for me.
Ronnie Richter.
Oh.
Mr. Blaine's partner.
Right. Any others? All right. Well, then we'll begin with you, Mr. Blaine, if you and Mr. Richter would come forward.
May it please the court, Your Honor. Ronnie and I represent 4 jurors who rendered verdicts in this case.
I would like their numbers, but only if that doesn't violate the attorney-client privilege. You may give them to me now or later.
Can I give them to you later? I have them now. Our job is we want to preserve their anonymity.
I understand.
2, we want to make sure that they're not harassed. And 3, we want to make sure that the verdicts of their conscience remain. And that is not only because they voted guilty. If they voted not guilty, we would feel the same way. After hearing what Your Honor has established by the way of procedures, we're very comfortable with what you have established to protect their anonymity and that they're not harassed. Ronnie came up with a good suggestion. Maybe you renumber the jurors 1 through 12. And that way, because there has been some public disclosure of the jurors' numbers in some of those emails, they were the big batch of emails that Mr. Harpoon referenced. So maybe we cross-reference with the chart 1 through 12 in the juror numbers. But as far as the questioning goes, there's no need for us to be part of this. You're going to make the questions. You indicated that you're going to preserve their anonymity, that they can't be photographed, they can't be on videotape, and that's about all we have to add.
Yeah, Your Honor, I would amplify that I certainly respect and appreciate the significance of the issues that are before you. And I respect your decision that you're going to make this public. I would have asked you to make the jury portion a closed courtroom. And Your Honor, only for this reason, that I don't know what the jurors are going to say, I don't know what you're going to rule, but let's just say in a hypothetical setting that because juror number 9 said something that you believe deprived Mr. Murdaugh of his right to a fair trial, you're going to grant a fair trial, a new trial. I would hate for there to be any mechanism for somebody to backtrace to who was juror number 9. Because I know the public has very firm opinions about this matter, and I wouldn't want that person to be subject to any kind of public scrutiny. So I would have asked of you that for the juror portion that we do closed courtroom, that the press would be present, that their likeness, both voice and face, be muddled, just as an additional safeguard. But I certainly appreciate what the safeguards you have put in place. I respect your rulings. I just throw that out for consideration. And on a broader perspective, I know that you've had this experience as well, Your Honor. It's becoming more and more difficult in this state to see the jury. And I can't think of anything more injurious to jury service on a broader perspective than to see, jurors who've given up 6 weeks of their lives being pulled back in for a process like this, as necessary as it is. So I worry that the process be handled as gingerly as possible, so as not to further prejudice our ability to get juries going forward.
Thank you, sir. What I will do is this. I think your suggestion of renumbering is a good one. It's something that my clerk and I had talked about between the two of us as well. In every proceeding I've ever seen where a juror was questioned, in every case I've read where jurors were questioned because of allegations either during trial or post-trial that they had been tampered with, those proceedings have been in open court. And I don't feel it would be appropriate for me to have some kind of in-camera proceeding, even if it included the attorneys that would have to, and even if it included members of the press, but not the general public. I don't think that is in keeping with the public nature of trials in this state and the public nature of court proceedings. However, I think we could make some protective arrangements for when they testify and their ability to be dismissed after they testify that would protect them from being set upon to the best extent possible. So that is the way I will handle it, and I hope all things on balance that is as protected as you think it needs to be.
We trust you, Your Honor.
All right.
Your Honor, on behalf of our clients, we will accept their service of the subpoena so that they don't have to be served.
Well, that's great, and of course, you don't represent all of them.
No, our four.
You're for, but that's great, and it may very well be that these parties are going to be able to work out something with respect to some of the rest of them. I don't know, but I appreciate that on behalf of the ones you represent.
Do you want me to come up and tell you our juror numbers, or you want me to wait?
No, sir. You can. I don't need that this moment.
Okay. Thank you.
Thank you, Judge.
Yes, sir. Mr. McCulloch.
Sorry, would you like me here or there?
Oh, go to the podium if you would, please, sir.
I believe by some of your rulings today, they've satisfied several of the things I was going to mention. One, Your Honor, was, of course,
How many jurors do you represent?
I'm sorry, Your Honor, I represent number 785 and 630. One is was a deliberating juror, I suppose we call her, and the other was the removed juror.
Right. And with respect to the replaced juror, I think my ruling about the end of any testimony from that juror satisfies any requirements you made. I believe that I will not hear testimony from that juror, alternate juror at the present time. Now, Mr. Harpootlian is going to submit additional information. As regards your client, I'd ask you to submit that information to you as well. And then I'll see if there's any revision of the position I'll take about that. You also represent one sitting juror, so you may continue.
Your Honor, the other juror was not alternate. She was an actual seated juror.
That's right, the sitting juror.
Who was removed at the end of the trial.
Oh,
Prior to the election. Whoops.
I need Mr. McCulloch to speak up, please.
you need to speak up some, Mr. McCullough.
I don't get that much, Your Honor.
Yes, sir.
Your Honor, if you'll indulge me just a moment, I think much of what you've said today bears on a quote that I'm taking from the response of the state, which was filed and was part of your record. And my letter of November 10th responding to that filing is also part of your record. But the state said that jury duty is this cornerstone civic duty, needless exposure of jurors to litigative stress and impeachment by zealous attorneys in a case especially of this public exposure can only serve to discourage citizens from willingly participating in this civic duty. Your Honor, I'm delighted with your ruling that you'll be asking questions. I've been subject to your interrogative skills in my appearances before the Supreme Court. So I'm pleased with that, and I check that off the list. I would like, Your Honor, for you to take judicial notice that there have been excessive public comments by, and I have to say, Your Honor, in my letter of November 10th, I took Mr. Waters, who signed the letter, to task for labeling one of my clients, one of these jurors, as dishonest. I think I wasn't pleased with that. I think that discourages civic participation. I would ask the court to admonish the litigants,
I'm
attorneys.
not, Mr. McCullough, let me stop you there. I am not aware of any of what you're talking about in terms of comments about jurors or otherwise. So that's just not something I'm gonna take into account by listening to it or by taking any judicial notice of it. I don't know what I would be taking judicial notice of. I do not know anything about what you're talking about.
Well, Your Honor, both my letter and the response of the state are part of the record, which you obviously have not gotten to, but I would assume yet. My only request is I would admonish lawyers, officers of the court in this courtroom and outside of this courtroom who represent people to be cautioned that this is a search for the truth, not an effort to protect the verdict, nor an effort to discourage people from participation. Negative commentary doesn't, or rise the risk of doing that. That's all I'm saying.
I understand, and I decline to instruct or admonish participants in this procedure in any way about what you say.
Thank you. Your Honor, next, I like Mr. Richter and Mr. Bland, appreciate your efforts. I suspect that we will decline a ride to the courthouse, but I would ask the court to consider allowing the jurors who choose not to ride with SLED agents to be permitted an entry and exit from the courthouse that would involve or relieve them of the necessity of coming through the front door.
I think I've already said that I will make arrangements for juror witnesses to report to the basement where the law enforcement station is, and they'll be appropriately directed to the assembly room.
And Your Honor, lastly, I think, if I understand your rulings or discussions about the process that will occur here, this may run at odds with it, and I'm not arguing with you, Your Honor, you know best. I am of the belief that this litigative stress that I earlier referenced could be avoided, and the public and media not denied their opportunity to gain access and knowledge of the proceedings by not exposing these jurors to a crowded gallery and a full gallery of press by allowing its recording through, I understand Court TV will be the pull camera. That is to say that I have actually gained access and knowledge of the proceedings by not exposing these jurors to a crowded gallery and a full gallery of press by allowing its recording through, I understand Court TV will be the pull camera. That is to say that I have actually, in my history, participated in proceedings that involved the questioning of jurors, which was done in camera. So I don't think it's without any precedent, but I would obviously respect your ruling, but I would ask you to consider or reconsider that no damage would be done to the right of the public to know and participate in the proceedings, but you can accomplish the same thing by allowing the pool camera and avoid the distraction and the imposition of that on these jurors. And
I hear what you're saying, and I'm not inclined to change the ruling I've made at the present time, but I'll keep an open mind about it as we make pre-trial preparations for the hearing. At the present time, the jurors will be examined in the courtroom, as I have indicated, with appropriate identity protection.
thank you, Your Honor. And subject to your rulings, I will have both of my clients available for these parties as they might be needed, subject to your subsequent ruling.
Thank you.
Thank you.
Your Honor, do you expect all jurors to be present for all 3 days?
So, let me make it very clear that I expect the jurors will be the first witnesses to be called in these proceedings. And the jurors will testify, and then they would be dismissed. They would not be required to stay for the rest of the proceedings at all. So that is very much a part of my thought about what it takes to protect their identities. They would be protected as best I can, and the ability of others to come and to set them with questions as they leave would be protected. So,
Do you expect that you can get through all 12 in one day, or should I tell them, because a couple have to take off for work?
yes, I do.
Okay, thank you.
All right, and Mr. Lewis.
Your Honor, I'll be brief. In light of your rulings, I don't think you need much from me. The only thing that I'll add is I'll have Ms. Hill available for here as the parties need, and I'm happy to accept service to alleviate one issue for this court. unless you need anything from me, Your Honor.
All right, thank you for that, and, before you, leave the podium, let me just consult with the lawyers. I'm not going to ask them to examine you, that wouldn't be fair at all, but I'm going to ask them, if there's anything else I need to inquire of before I let you go. As I understand it, the subpoena, and we would have a formal subpoena of Ms. Hill would be, placed in your hands, as her attorney. And you would assure her appearance, and I appreciate that very much.
Absolutely.
Is there anything else, on behalf of, Mr. Murdaugh?
Your Honor, just in an effort to try to expedite this matter, I have two questions. One, will Ms. Hill meet with Mr. Griffin and I?
We'll evaluate that.
You'll evaluate it. Okay, that's all I can ask. And secondly, should we have her here on that Monday or wait? I mean, if you're going to be doing the jurors most of all
She should
day.
be here on, as court begins.
All right, thank you.
Nothing from the state, Your Honor.
All right.
Thank you, Your Honor.
I'll go over my checklist one more time, but I think I've, covered everything I want to cover. I'll come to each of you in a moment. Yes, just to clarify other witnesses, as matters now stand, the witnesses in this proceeding would be jurors and Ms. Hill. All right, so I want to be sure that we're all understanding exactly what's going on in that regard. I would not allow the attorneys to be called. I'm unclear about the mention in some of the papers that SLED investigators would be asked to testify, or any other witnesses. So I'm going to go one more time. I want to get real specific so you will understand what you need to prepare for by way of in-court examination and what you need to prepare for by way of submitting proffer. All right, first of all, for the defendant.
Police Court, Your Honor, just a couple of issues. One, we don't know who we're going to call to impeach Ms. Hill. Because we don't know what she's going to say. So it's difficult for us. I mean, once she testifies, at that point, we'd say we'd like to call so-and-so and so-and-so and such and such and such and such, number one. Or maybe no one. I mean, she may concede every issue we have. For instance, she did tell, according to the state, she did tell one of her assistants, one of the people helping her, I hope he's found guilty because it'll help book sales. Now,
I hope that's the last time you're going to repeat that until I ask for it again, Mr. Harpootman. I've told you that I can't imagine a situation in which I would go that far. So a statement like that, and she may well have said it, if it goes to anything I'm asked to consider, it would be to her credibility. And I'll evaluate whether I think that's even proper to ask, but let's move on from that.
but there are other questions concerning her credibility.
Yes, sir.
404 motive. If she did this, it is a crime. And so, the questions of why she would have done this extraordinary act, and we can argue this at another time, but in terms of me the reason I mention it is for us to proffer those people now, not knowing what she may admit, that question may get asked, she may admit it. There's no witness that needs to be called. So it's difficult for me to game this out. I don't think I've ever been asked to list witnesses I would call to impeach somebody if they lie under oath. I've never heard of such a thing, but I will attempt to do the witnesses we would call prior to Ms. Hill's testimony. That's all I think I can do, if that makes sense.
It doesn't make complete sense to me because this is not the trial of Ms. Hill. And issues about motive and so forth and the possible commission of crimes are not what this inquiry is about. It is about her contact with any of the jurors and what you said. So I will be treading very carefully with a good deal of what you say about what you might or might not ask. But I am going to ask all the parties to be pretty specific with me about what I should be asking the jurors, and I can make a decision in advance as to what I am going to do about that. And what is going to be, at least by general topic, pursued with witnesses.
Yes, sir.
And the reason I do that is because it gives me the opportunity to then consider what rulings I would make and move the proceedings along in an orderly way.
Well, Your Honor, it may be premature for me to note this for the record, but we would accept your ruling on that.
All right.
Okay. Secondly, Mr. Murdaugh has been unable to review any of the discovered material in this case because of the confidentiality order prohibits us to distribute to him while he's in jail. We don't have time in the next less than 2 weeks to go sit down with him and review everything. Would Your Honor allow him to have them? And the materials are not as to the evidence in the underlying case, it's as to juror issues. And while he is no longer a lawyer, he was a lawyer at one point and can evaluate this and be of assistance to us if he has an opportunity to review that material.
You're speaking to me about something in a complete vacuum as far as I'm concerned, so I can't really evaluate what you haven't been able to review with him and what you have been able to review with him. As I understand what you're telling me is I have received certain information as the attorney for defendant that I have not been able to show defendant for defendant's review because of the confidentiality order. I can't imagine that. I think what you may be saying is Mr. Burke has not been able to keep for himself while I'm not there confidential materials.
That's correct.
That is something common to many folks who are under incarceration are limited in the kind of materials that they can receive and keep in their possession when they're not with their lawyer. This is not an issue where he's being deprived of the ability to consider material that you have received. This is a question of whether he can have that material in his possession when you are not there or your representatives are not there and study upon it and so forth. I can't control what the limitations of the Department of Corrections are, nor can I control what limitations may have been put on confidential material because of the fear that it would fall into other hands. So I'm not going to rule in the abstract on things. I would have to have something pretty specific, but I can tell you this. I would certainly not order that these materials be wholesale given to him for him to take back to his cell and have in his possession, because I don't know who might see them were that the case. And if they are confidential materials, that would be an extreme risk of breaching the confidentiality of materials to do that because of his situation. And his situation is as it is, not my making or yours.
Your Honor, I would only note for the record this: much of the material we received has been within the last 2 weeks. This hearing is scheduled for 2 weeks from yesterday.
Yes, sir.
And you've given us more stuff we have to do between now and that hearing. There's nobody to go sit with him at the jail, and his time is limited as to when those people can visit. So without him being able to review this material, I don't believe we can be effective, and we would be ineffective in representing him.
Well, I understand that those are wise statements for an attorney to make to preserve your position on the record. It doesn't change my view of how we should proceed in this matter at all. I think you will be able to, if there are deficits in what you have been able to do with your client, you will place those contentions on the record, and the appellate courts of the state will have adequate chance to review.
Well, Your Honor, would you consider continuing the hearing on the 29th to allow us to meet with the client and effectively review these materials?
No, sir.
Okay.
Thank you.
We respectfully accept your ruling.
I understand.
Thank you.
Mr. Waters?
I don't have much to address, Your Honor. The initial question that Your Honor asked was about SLED agents being listed on the potential witnesses. And, you know, again, Your Honor, when these allegations were first raised, we instructed SLED to do an independent investigation, good, bad, or ugly. And only because of the results of that investigation, or the reason why we're standing here and litigating these issues before Your Honor. Ultimately, the only way that SLED agents could potentially be testifying, and again, when we filed our response, we didn't know exactly the parameters the court would rule. The only way, though, that I can see them potentially testifying is in the event that there is an accepted witness by Your Honor, that there was some sort of prior inconsistent statement under Rule 613 or some other permissible inquiry. But I think Your Honor's rulings as to the nature of the inquiry we're going to conduct would probably remove or make it very unlikely that need.
All right. Anything further?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
All right. I say to attorneys for both sides, the court is deeply grateful for the very fine materials we have submitted so far. It's an extreme amount of work in a very truncated period of time, and I appreciate the burdens it places upon you, Mr. Hopkins, and I particularly thank you as a member of the General Assembly for not interposing your immunity because you are in session, and I respect that. I set these matters after consultation with y'all so that I could fulfill my obligations to the court as expressed in Chief Justice Beatty's order. But I realize that I'm doing that with your extreme cooperation in light of the other duties, and I appreciate it very much.
Thank you, Your Honor.
I look forward to further submissions from the parties and from the hearings commencing January the 29th. Court will be in recess.
Thank you.
Thank you, Your Honor.
I asked Ms. Harris before these matters commenced to please expedite, even if it's in a rough form and not in a perfect form, the court would like to produce their transcript. I asked her to produce a rough copy of the transcript just as soon as she possibly could for both sides. I hope you all will consider, without me having to order, sharing the expense of this production, this early production of the rough copy of this matter. She will be in touch with you. You may be in touch with her with regard to the rough transcript of these proceedings. We'll be in recess.
Thank you, Your Honor.
Still raining outside.